Every day in the USA, people find themselves in court.
Montreal, Lightfoot,
Here's my next one.
Montreal. Yeah. If we go from Spanish to French,
That was better. Is it Montreal and Spain?
Montreal, Lightfoot, is he in custody?
Yes, he's
Okay.
good. Yeah, he's not with us. Subject.
Come on up, sir. 25 CR 715 is now called Montreal Lightfoot. You are Mr. Lightfoot? Yeah, okay. She asked to hear everything. Thank you. You were here with Mr. Burbank, your attorney and the state's attorney. Earlier, you were indicted by the grand jury for the third-degree felony of deadly conduct by discharging a firearm at or in the direction of another individual. And did he enter his plea already? I'm not
He
sure.
did, Judge, back on December 1st.
And a pre-sentence report has been prepared. Have the parties had an opportunity to review it? Any corrections or changes to it?
None from the state, Your Honor.
Defense has. No,
Has none?
no.
All right, then it's made a part of the record for all purpose. I believe the agreement here is that whatever sentence shall not exceed a cap of 6 years in prison. So he's looking at for the third-degree felony, no less than 2, nor more than 6 years confinement in prison. He could be placed on deferred or unadjudicated probation for up to 10 years in length. And regular probation, I don't believe is an option. Is that right?
That's correct, Judge.
Go ahead. State, you can go first and last.
I'll defer to the defense, Judge.
Yeah.
I'm sure you would.
I like responding to your arguments.
The thing, I've got, there's my highlight. Mr.
There's some
You should
concerns,
state.
yes, there's some concerns.
We're back to this. I don't know what's going on back there, but everybody who pleads guilty comes up and denies they're guilty now.
It
at the
must
time of
be
sentencing.
the orange juice that they serve back
Yeah.
at the jail,
That's
Judge.
what I'm thinking.
I have looked at Detective Joshua Jackson's response. And also the victim in this case, Mr. Mendoza. But then you also take the defendant's version of it, and I don't have really a response. It kind of goes contrary to the evidence that I saw and the discussions that I've had with my client. Also discussions with the district attorney, and coming with this, there were a number of defendants in this case. The offer, I believe, was basically all the same. I was hoping maybe to place him on deferred probation. But it is totally up to the judge based on the totality of everything. I was even hoping to have less than 6 years. I have nothing more to say.
What are you asking for?
Well, you can put him for anywhere from 2 to 6. It's he used a deadly weapon, so I guess it's a 3G offense. So he'd have to do half the time. He's been in for a little bit now, and so I think it's more of a based on what you have here and his past and all the other things that have occurred. Maybe 10 years probation to try to straighten him out. But the indications are that you may be spinning your wheels here. I'm being totally frank or honest with the court, especially if someone doesn't take responsibility. And I know I'm speaking in reference to my
I
client.
understand.
He's a young kid. His actions that were described, in the PSI report from investigating officers, especially with this type of charge and looking at penitentiary time, it's not good. So how can I make the recommendation? As an attorney, would love to give him a second chance and put him on probation, but I'm going to set him up for failure immediately. But this is a third degree felony, which is 2 to 10, and the cap is 6. So you're looking at another 2 years if he's convicted of the 10 years.
Well, something kind of more than that. He's on parole from the juvenile system for several violations.
Yeah, I think
He's on parole and he commits this crime of deadly conduct. And he's been through the system
Yep.
since 21
Mhm.
and evading arrest, unauthorized use of motor vehicles theft, violation of juvenile orders, violation of juvenile court order, violation of juvenile court order, and then parole, a form of parole that we really don't deal with too much from the juvenile system, but he was under a form of supervision when he commits this third degree felony of shooting, being with some or a party to it, shooting firearms at others. And we're talking about AR-15 style weapons here. But he pleads guilty under oath. And then we have this pre-sentence report. So what are you asking?
We're asking for a deferred judge.
Go ahead.
Judge, you probably have 6 to 10 individuals that are going to appear separately at different points in times in front of you out of this particular fact situation. Some people in the courtroom and those listening will remember this nonsense that occurred back in May of 2025. The facts are that there was a shooting, that there were 2 people in this particular scenario that were armed with AR-15 style rifles. This is one of them. He's a menace to our community. He is making Jefferson County unsafe. We cannot do anything to get this man's attention other than to put him into prison. This whole scenario and what our community keeps having to deal with in Jefferson County makes a lot of us fearful to sleep at night. When Mendoza states here that after getting shot that he believes that young people deserve a second chance, I agree with him. He even said that after 6 to 7 bullets entered through his apartment, and he was one of the people that is the victim in this particular matter. But it's that senseless level of violence that drives us to try to do something different. Detective Jackson, who's present in the courtroom, is mortified by having to deal with these type of matters. And what is more compelling about this young man and why it is that we can't help him by probation is the fact that he's shown no remorse. He's accepted no responsibility. When he was interviewed by the police department, he basically laughed about this, singing and dancing during the periods of times in which this was being interviewed. After toting around an AR-15 on surveillance video where shootings occurred and somebody could have been killed, all while he was on parole. I just don't know how you help somebody who will not help themselves. That's why, despite his age, I asked that what's most appropriate is that you give him 6 years.
Anything else?
No, Your Honor,
You want-
unless Mr. Lightfoot. would like-
Did you want to say anything, sir? All right. The pre-sentence report is made a part of the record for all purposes, and the pre-sentence report includes some information. Essentially, the defendant's version of all of this at the end of the day was, I was in the wrong place at the wrong time. The victim of this case states, I feel as though everyone deserves a second chance, but not when you just randomly shoot at people. He should not get probation. It was several of us in my apartment at the time, in their home. When gunshots rang out, we got on the floor. A friend's car was shot up. I think 2 groups thought the car belonged to another group, not us. There were at least 6 or 7 bullets that entered these people's apartment from the outside. Because you and others are shooting at each other downstairs, and then people are trying to live, and then you got 6 and 7 bullets whizzing by. What kind of place is this supposed to be? This is the United States of America. We're supposed to have better than this. And he states, I don't deserve what happened. I even had to move out of my own home. This was supposed to be a safe space. Well, the detective in this case, his summary is pretty good. And it summarizes what this is all about. Chaos and irresponsible, lawless behavior by you and others. This is a case where multiple persons, multiple humans could have been killed. As a result of shooting at others, one of them was struck with gunfire and was rushed to the hospital. And another one was shot in the arm. When they arrested you and were investigating, your attitude displayed no concern. You were bothered by being arrested, knowing that people's lives had been jeopardized, people could have been killed, and somebody was shot. You were singing and dancing during the interview, having a good time. No remorse or showing of any care whatsoever. After being told what charges you would be placed under, you started singing and dancing again. Took no accountability for your actions. And this is all while you had been dealt with more than once, numerous times under the juvenile laws for your irresponsible behaviors of evading arrest, unauthorized use of motor vehicles, thefts, then violations of your juvenile court orders, and you were under a form of parole with the juvenile system when you were involved with all of this. According to the probation office, you failed to take responsibility for your actions and blamed it on others and stated you were just in the wrong place at the wrong time and expressed no remorse for the victims. Any success rate on probation is poor, according to the probation office. Anything else after all of this? Did you want to say anything, sir? You don't want to say anything? You were doing a lot of singing and dancing at the time that they were investigating. You don't want to do any talking now?
Oh, what they talking about? Not saying
You weren't, they were lying. Everybody seems to have had a different story. here. The investigation is completely different from what you say, but you're the one in all the trouble. You're the one with all these juvenile violations. You're the one on parole. You're the one who shouldn't have been even out there around any of this. What kind of parole are you following? Parole laws don't allow you to be doing some of this, but yet you're doing it anyway. But the most important thing is you looked me right in the eye and stated that you were guilty of this crime under oath. Didn't you?
Yes, sir.
Were you lying to me? Were you lying to me under oath?
No,
You want to add perjury to everything else?
no, yes, sir.
I find that you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in your plea hearing to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this serious third-degree felony of deadly conduct in discharging a firearm. I'm following this agreement. You are found guilty beyond a reasonable doubt. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. And the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir? Yes?
Yes.
Yeah,
Okay. That is all.
Wow.
Reyes Castaneda. Three cases?
Yes.
Oh, boy.
but he has-
Third-degree felony of evading arrest or detention, third-degree felony possession of a prohibited weapon. I wonder what that was. Tell me it wasn't a nuclear device, a machine gun. And third-degree felony of obstruction of retaliation. So you're looking at 30 years in prison total on all of this. Each of these are third-degree felonies. Okay, today. Yeah. Okay.
And Judge, he just got arrested 2 days ago for another felony. He just got out of jail last night, I think. About 8 o'clock.
I'm being told that that's gonna be another indictment that's coming.
So unauthorized use of a motor vehicle. It's a
Nothing
state jail.
What do we know?
I don't know anything about it. I just found out he got arrested and they released him on accusation bond out because they didn't file a case yet with us. So as soon as I get something in, I'll know a little bit more. And if it looks like something I need to file a motion to have his bond yanked, I'll
Well,
file
I
it.
need,
But
the court needs to know something about it.
yes, sir.
Right.
I don't have anything right now.
Well, he's dancing around about bond. There's a new arrest. That's on my watch now.
If you can reset it a week, I can get a hold of everything and
Nope.
or
I
just,
got to figure out something now, if
Okay.
possible. Can you get a
I'll see what I can do.
report or something?
See what I can do.
You're going to sit right over there. You in the penalty box. Thank you. Mr. Castaneda? Go on. I'm getting a probable cause, a copy of a probable cause affidavit that is prepared by an officer with the Beaumont Police Department. And this states that this event occurred on January 17th. 4 days ago? Well, you're on my bond. In reference to to attempting to locate a stolen vehicle. I later located the above described vehicle at the Smart Shop on Avenue A, and a felony takedown was performed. Further investigation revealed that Reyes Castaneda, that's you, was located in the driver's seat of the stolen vehicle he was operating. Due to Reyes being located in the stolen vehicle and operating without effective consent of the owner, he was placed under arrest, secured in the rear of the patrol automobile, and he was booked in. And there's body camera footage on all of this. So this just happened 4 days ago. So a copy of this is going to be made and it'll be part of the record on this hearing. What's his bond?
One. He has 3 cases with us.
Mm-hmm.
15,000.
It's what?
15. 2020 and 15.
55. All right. The state asking for.
That's due to the fact that he's been arrested on a new charge while on bond. We believe the bond to be insufficient. And we've asked his bonds at least be doubled.
Defense.
And Judge, as I'm sure you're well aware, bond is used to ensure that the defendant shows up for his court dates and that that it's set sufficiently high enough to make sure that he does show up for those court dates. And even though we have this new issue that arose this past week, he got out yesterday on accusation, did not have to post another bond. However, he still showed up for his court date today. So my argument is that his bonds are sufficiently high enough as they sit currently because they ensured his presence at court today, a court date that he has had and that he knew about, and he was proactive enough to be present today. So I would ask that once the new indictment comes, there will be some kind of a new bond assessed for that, but I would ask that he be allowed to remain on his current bond and maybe increase the current bond conditions instead of revoking them.
Now you increase, don't commit another crime while you're on bond.
All right. The court is going to note that Article 17.15 of the Texas Code of Criminal Procedure sets forth rules for setting amounts of bond. The nature of the offense, circumstances under while the offense was committed are to be considered, including the future safety of a victim, law enforcement, and the safety of the community are also to be considered. And considerations of bond also include whether the defendant has complied with other bond conditions and the safety of the community and the circumstances of this crime, of the crimes that we're dealing with the defendant all show that he's free falling and he is a danger to the safety of others. His bonds are revoked in each case and they are doubled from 20,000, 20,000 and 15,000 in his 3 current offenses to 40, 40 and 30. So that's those are going to be the court ordered bond amounts. Plus you must have a GPS device on you at all times. You must stay at home confinement. You can only leave home for purposes of emergency hospitalization or medical needs, to and from food sources in the most direct route possible, and to and from your attorney's office. Those are your exceptions to your confinement if you post this bond. What do you want to set next? An announcement here?
I'm not sure when the new offense is going to be indicted, but it makes the most sense to set it after that.
Let's look at a review in
maybe
4 weeks.
Okay.
And Court's Exhibit 1 is a probable cause affidavit that is been prepared by law enforcement in this particular underlying case of the defendant being in possession of a stolen vehicle on January 17th, 2026. And it's prepared by the Beaumont Police Department. And it will be made a part of the record in each of these three cases. All right, anything else on this?
Mayor.
Resolve.